All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in 1 CA CV 180243, DRISS versus DRISS. I will let you know that these proceedings are being audio and video recorded. So I would ask counsel to please identify yourself and the party that you represent at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel, you're advised that you need to watch the clock. If you want to reserve any portion for rebuttal, it's your responsibility to do so. We have read the briefs. We have discussed this case in conference this morning, and we are familiar with both the record, the facts, and the arguments. Counsel, you may begin.
Thank you, Your Honor. My name is Eddie Doman, and I represent the appellant in this matter, Dr. Leon DRISS. I know the court's familiar with the arguments in the briefs. There's three primary reasons that we believe a reversal is appropriate here, with one of which, the first one, having two categories. The first is the idea of the spousal maintenance being awarded at all based on the division of the property. In this case, the wife's employed a job that provides $77,000 a year in income and was also provided approximately $1.7 million in additional assets. In the court's decree, although those assets are mentioned, no earning potential of those assets was set forth, even though half of them consisted of liquid assets such as cash, investment accounts, money that you could easily have access to. This court, in other contexts, has recognized rates of return that the government puts out as appropriate rates to use. The example that's set forth in the brief is that for post-judgment interest, the court's recognized Form H-15 that the Fed puts out and does a post-judgment interest rate of prime plus 1%.
Did you offer any potential rate to the trial court to use on this? And
Your Honor, there was no.
And did you offer it as to a specific amount? Because obviously some of the assets were not liquid.
Yes, Your Honor. Mrs. Driss was questioned about her meeting with a financial advisor and couldn't recall anything that was said about the amount. There was no specific testimony about an amount other than it being recognized that 2% is not enough. But when you look back on this court's decisions on this issue, the trial courts and the appellate court upholds it, often approve an amount that it appears there's no testimony for in the record. I mean, even when you go back and look at the Deathridge decision, which is important here for two things, one of which is that you also need to consider the return that someone gets on real estate when deciding whether or not an individual has been given enough funds to support themselves. But more importantly, even though that's the reason that the trial court's decision was reversed, the trial court also held that for the liquid assets in that case, which consisted of cash and an investment account that totaled approximately like $54,000, that the court felt that a reasonable rate of return for the time period when that decision was made would be 10%. But the case doesn't talk about a financial advisor or anyone else testifying to that amount. And
I guess my question wasn't clear enough. My question is, did your side present to the trial court saying, Judge, we'd like you to impose at least a 3% or a 5% or a
2% amount was discussed
with the court
by counsel. Yes, when addressing this issue, a comment was made that even if you use 2%, there would be sufficient funds here for her to support herself.
That was separate and apart. You're talking about when you broke this out, it's your number one. She isn't entitled to spousal maintenance.
Yes,
so what I think, and maybe I'm wrong, but what I'd like to hear is this. In the trial court, when issues of her ability to support herself were brought up, did you or your client bring up the fact that she would have income from the investments that should reduce the amount of spousal maintenance?
As to a very specific number, I think the answer is there were no specifics involved. However, there was questioning regarding the meeting with the financial planner to determine what she had told a particular rate of return would be on the money. I mean, until after the divorce decree, you don't even know what funds it is we're talking about. So it's very difficult for someone to testify as to what the rate of return would be before you even have a decree that's stating what assets someone...
But the question is, I mean, it's partly what the testimony was, but the other part of the question is what was argued to the trial court? Did you argue to the trial court there is some rate of return that should be imposed?
Well, again, it was mentioned that even if you use 2%, which is an extremely low rate, this was mentioned to the trial court by counsel as to even if you use this amount, that's enough. And I think that until there's further guidance from this court as to what specific testimony needs to be elicited, that it's not proper to hold this. Family law practitioners at this point are unaware of who needs to testify, to what extent, and I don't think it would be fair to simply apply that to my client in this context when it's inherently obvious to everyone that if you have money, you can make a certain minimum rate of return on that money.
Okay, let's accept that premise.
Yes,
Who
sir.
is supposed to bring that to the court's attention? Is the court supposed to sua sponte say, what do you think the rate of return and how much monthly would she receive from those investments, and give different scenarios? If she was awarded this, she would get this. If this, then this. And then it would give the trial court some numbers to do that with. Nobody asked the trial court when figuring her income, and it's $77,000 that she makes from her job,
Yes, sir.
to include... Can we go, ma'am, please?
Yes, ma'am.
Thank you. To include...
Is that my accent?
Okay, now I'm used to accents.
Me off there.
Yeah, I was like, is he talking to me? All right, let's get back to it. $77,000 is what was presented to the court by wife, correct?
Yes, Your Honor.
Whose burden was it to say, you got to add that interest, and I don't know what the interest is, but trial court, you're going to have to figure it out, and we want you to use this rate of return, and we believe that's reasonable for whatever you decide. I mean, I don't like a situation where a trial judge is required to tick every box when there are lawyers that should be ticking it for him, so him or her. So, explain that to me.
Yes, ma'am. I believe in this particular situation, based on the decisions that exist up until this point, my concern reading the cases is you see cases where they just give a rate and nobody testifies to it. And I understand your position that you should ask potentially for a particular rate of return. But at this point, it's unclear. I mean, if the lawyer just asks that with there being no support for the number, I mean, would that be sufficient? I don't think parties that aren't involved in the investment industry are qualified to give testimony regarding a potential rate of return. And the same thing is probably true for these business valuation people. I mean, as far as what a proper rate of return would be on a substantial amount of liquid assets, which is why we make the argument, you know, well, even 2%, which is a tiny rate, or in the reply, use prime, use the treasury bill rate, use the average of the S&P 500 for a certain period of time. Or the court can simply set a statutory rate to use for liquid assets. Because when you're talking about the real estate, the courts even recently said, okay, this one husband gets all these pieces of real estate that have earning potential. There's no evidence regarding what that earning potential is, but trial court, you need to consider it in determining the amount of spousal support and whether or not it's necessary.
So how do you, in a perfect world, see this going? I mean, what procedure... let's just suspend the rules discussion.
Yes,
but... So wife would have to prove up her income for a spousal maintenance award. And who would who would bear the burden of proving up the interest rate? Or would we just have competing experts discussing it like we did on the business valuation question?
That's why I think that a reasonable rate should be applied by the trial court, because I don't think the family law courts need to get burdened by having 2 additional expert witnesses in every family law case where substantial assets are being distributed.
So if your client had received that 2% that you say is in the record, attributable to wife as income, we wouldn't be here on that issue?
That, well, if you apply it to the entire amount, correct. And even if you just looked at the liquid assets.
I'm saying, you can't apply it to the entire amount because some of those assets were not
Correct.
going to generate income.
Correct, but even if you applied the Treasury bill rate, which I think at the time of the brief was 2.61%, and you just apply that to the cash and the investment accounts, it ends up being $21.40 a month, which is just shy of the $2,200 a month that was awarded by the trial court. So even if you just apply the Treasury bill rate, which I don't know anybody that actually invests in, other than large investment companies, and is the lowest rate that you can kind of get on your money, even if you just applied that, and even if you only applied that to the liquid assets, you'd still get an amount that is just shy of the $2,200 that was awarded. And that's why I think until there's a rule or a decision that specifically states you have to have someone come in and testify as to the return, be that a party or someone else, I don't think it's fair when you're talking about.
Well, let's step aside from whether or not there was some trial testimony for it. Did you make this argument to the trial court in a motion for new trial or any other post-judgment motion that would indicate to her that, oh, by the way, Your Honor, you missed the boat here. You needed to impose at least a minimal amount of interest on the assets?
Your Honor, I believe there was a post-trial motion
and
regarding
did you include
that. I know that it talks about the 1.7 not being considered. I don't remember the very specifics of the actual motion for a new trial as opposed to the appellate brief on the issue, but my recollection is that I don't.
And you gave the trial
2% number, I believe, is in there, but I'm not 100%
and
sure.
so you gave her an option.
Yes, Your Honor.
And she denied the
I
motion.
believe that's correct. Yes,
Okay.
I'd have to double check that pleading as opposed to the briefing, but I believe that's correct.
All right.
The second issue I want to touch on related to this is the idea of the extraordinary work regimen that was used to determine the husband's income as it relates to the consideration of spousal support. The trial court, in its decree, other than not attributing the extra 10 to 15 hours, found that the husband was working 45 to 50 hours in the practice and 3 to 7 hospital sessions that total 12 hours a month, which ends up averaging to 56 to 75 hours a week. Which I don't think, and he also testified that he didn't want to work those hours anymore, which precipitated the filing of the petition for dissolution.
And counsel, you're
Yes,
going to have to point
ma'am.
me to the record where he said he didn't want to work those hours. When I reviewed the record, this is what I came up with. He said he'd been working that for over a decade. He intended to continue doing that so that he could keep his practice open, and that his extracurricular was to supplement the income so that he could keep his practice open for the people of Pine Top Lakeside. So if I'm incorrect, I need to know where I went awry.
Yes, Your Honor. It's in the transcript at page 239, line 22 through 240 at line 4.
Okay, 329.
239,
Okay.
22
Okay.
to 240, line 4.
Okay.
And he says he wanted to reduce his hours.
Correct. He stated that it was being
Immediately or in the
physically
future?
taxing. Well, the discussion with his wife appeared to be that I can't do this anymore. I want to reduce my hours. And then the petition was filed. And so he continued working those 2 jobs. But the testimony was that he didn't want to do that anymore.
Well, but he clearly testified that he wanted to keep the practice, and he was a solo practitioner, so he was going to have to keep working those hours. So,
You mean in the actual? I'm sorry, Your Honor.
Well, what of the other jobs was he giving up?
What's the other 2 jobs that he talked
Oh, I know
about
what they
not
were,
wanting
but
to
which
do?
was he saying? I want to give up this job, or I want to give up this
Right,
job?
yeah, the medical director job and the shifts at the hospital.
Which were minimal
what are
per
the
month.
extra jobs and the smallest portion of the hours that he's working in a given month?
The smallest hours that he's working and the majority of his income.
Well, I mean, it's close, but when you add them both together, I mean, but clearly his primary job is at his practice, which is the asset, that was evaluated, and which is what should be used for his income. The fact that he has these two additional jobs, the court has recognized, even our court, that when you're talking about an additional position, a second job is the term that's used in the cases, that shouldn't be considered, at least as it relates to child support, and the same thing should be true for spousal support. Even the McNutt case makes that distinction when you're dealing with non-mandatory overtime.
So was the trial court, and I'll go back and reread your transcripts, but wasn't the trial court in a position to disbelieve him? To say, I don't believe you're going to give up these jobs. You've been doing this for over a decade, and you testified that you want to maintain your practice.
Well, I don't think that's even essential to the argument, because when you look at the McNutt decision, if you're not dealing with mandatory overtime, then that income shouldn't be considered for purposes of the child support issue regardless. It's if you're
Not child support, not spousal maintenance. Do you have any case law that applies that extraordinary work regimen standard to spousal maintenance?
Not specifically, especially not from Arizona.
Okay, I've got another question for you. So on the one hand, you're saying your client wanted to give up the hospice work and the hospital shifts and just keep his practice.
Yes, Your Honor.
And then you have the other argument that his business, according to Glenn Carlberg, had no value.
I understand.
How can all of that be true?
Well, if it didn't work out with the business, then potentially he could have worked the other two jobs instead of the practice and potentially sold the practice like you're saying, but the practice was treated as an ongoing entity, at the divorce time. So I understand the argument, but I believe that when you're dealing with an extraordinary work regimen such as this, that second jobs just shouldn't be considered when you're looking at the math, because if it's true for child support, then it's true for spousal maintenance.
And I see it kind of differently. The goals of child support and the goals of spousal maintenance are different. Agreed?
Yes, ma'am.
And spousal maintenance applies to couples that have established a certain standard of living and have been together for a significant period of time. That has nothing to do with child support. So your client had been working like this throughout their...
I understand, Your Honor. Yes.
So to say it's an extraordinary work regimen at this point seems a bit disingenuous, and I don't mean any disrespect with that, but explain that to me. Help me understand your point of view.
Well, I understand what you're saying about the difference between the reasoning of the two things, but when someone, in essence, it's giving someone else the benefit of someone working an extreme amount of work, and I understand your point that for spousal maintenance, and it had been occurring for a long time, but in my opinion, you're getting the benefit of a 40 to 50 hour job. It is appropriate, even when you're looking at the other factors such as standard of living and previous everything.
Rather than the court speculating that your client was going to change his work regimen, wouldn't the appropriate measure be when he changes his work regimen to petition the court because there's a significant change in income circumstance?
Well, but at that point, there's going to have to be payments made in the interim. And so
he's still working that amount. I'm not questioning. I understand you think there are some issues with spousal maintenance, but let's, for the purposes of this question, assume spousal maintenance was awarded appropriately. Your client's still working 3 jobs. He still has the same amount of income. He says he's going to quit working, which is a speculative proposition. 6 months or a year from now, he quits working the 2 jobs. Isn't that the time to petition the court to lower spousal maintenance?
I think it's proper to do it beforehand, which is what happened in that Straczynski case that I cited from Nebraska. And the court said it was error to consider the 70 as opposed to a normal work rate. And I do think that's fair because there's certain risks involved. If you quit 2 jobs and then the trial court disagrees that there's been a substantial change and that it should be changed, you may not be able to get those 2 jobs back, which is what you need to comply with the court's former order. I want to briefly touch. There's citations in the brief as far as the undisclosed rebuttal, which I do think the court relied on undisclosed testimony here. But I think the bigger thing, since I only have a minute and 40 seconds left, is the calculation of value being used to give an opinion of a value. I don't think this court should allow a simple math equation that doesn't consider expenses or liabilities to be the proper basis for the valuation of a business. I think you have to look at a company's assets, you have to look at a company's income, and that it's not proper to simply use a math equation. We cited to a case where this court had not relied on the calculation of value before.
I went and read that case, and it seemed to me that all the court was doing in that case was affirming what the trial court had done, as in they have discretion to consider all of that evidence, and we're not going to second guess what they do.
I think to an extent they do, although it's a little stronger than that because they use a precursor. Even if it didn't have to be excluded under 702, we still think it's proper to accept one opinion over the other. But I think it sets a poor precedent for this court to ever accept an opinion when it's not even allowed to be called an opinion under that industry standards.
If we took your line of approach, then all of a sudden we are going to then have to go through and substitute our judgment on which expert was more credible and which expert evaluation was more reliable in not only this case, but every single case that comes down the pike.
Your Honor, I don't believe that's true, simply because as long as one of them is not solely a calculation of value that doesn't consider assets or liabilities whatsoever, then you wouldn't have to do that. The biggest concern here is that it's just the calculation. That's all the time I have, Your Honor.
All right, thank you very much. Counsel.
Thank you, Your Honor, and good morning. My name is Sean Moore, and I represent Marilyn DRISS, the appellee in this matter, and with me at counsel table is Andy Lawrence. First off, I want to say that the arguments that Mr. Doman just gave would form the basis of what I think would be a really solid closing argument. He presented the weight of the evidence that they presented at trial in a compelling and rich manner, but unfortunately, that ship has sailed. The inquiry that we're asking now is whether or not there is reasonable evidence within the record to support the trial court's finding based upon viewing the evidence in the light most favorable to the appellee. And viewing the light and the evidence most favorable to the appellee, I think that the trial court's findings are easily supported here. Husband is really appealing two issues.
Well, let's talk about the spousal maintenance issue. And
yes.
but I want you to jump to it.
Go for it.
I don't understand how the trial court can give 0 as the basis upon the earnings on assets. It seems to me that if you have liquid assets, you have to attribute something. And I think that's what the case law would say.
So I have a couple of responses to that, Your Honor.
That's why I asked the question.
Right. The first one is the amount of liquid assets that wife received in this case has been heavily overstated by husband's side. They attribute...
Did she receive some? Let's start there.
She received some measure of liquid assets. Okay. I think it was something less than $100,000 total, Your Honor, as opposed to the $900-something thousand that they attribute to her. A lot of those are, a lot of stuff they attribute as liquid assets are real estate and retirement accounts that she cannot access without penalty before reaching retirement age.
Real estate, theoretically, she could make.
But it's not liquid. Liquid is something you can turn quickly into cash without any costs in the transaction, and real estate does not.
Let's call it assets with earning potential or actual income.
Sure.
So when we talk about it and couch it in those terms, counsel, here's what we need to know.
Sure.
We're in trial. We know nothing about what the division of assets will ultimately be.
Sure.
The trial court is trying to figure it all out, and I don't ever want to put a trial court in a position where they're responsible to make sure that they've gone through the testimony, because quite frankly, that's your job.
Right.
Who do you think should present the amount of income? Should it be a percentage? Do you think that they always should attribute interest to income earning assets?
Well, I think that just as not even in this specific context, I think it's a general rule that if any party wants a trial court or a fact finder to arrive at a certain finding, they need to present evidence in front of that fact finder upon which they can arrive at that finding. So in this particular instance, narrowing it down a little bit more now, if husband wanted to make the argument that the assets that wife is receiving in the resolution of this case will in fact produce income, it is incumbent upon him to present evidence that that will in fact be the case. But sorry, Your Honor,
before I lose it, because I'm coming along.
Yeah.
All right. So what Mr. Donman said is 2% was bandied about. Do you recall that?
I do not recall that, Your Honor. I mean, it's possible that it's in there, but I do not recall it.
And you
personally.
would agree that your client received a Sunrise investment account?
She did receive she received part of an investment account.
And you agree that there are annual distributions from that investment account?
As far as
there's testimony to it.
As far as I know, Your Honor, yes, there are distributions.
So we have testimony of additional income wasn't attributable to income in the spousal maintenance valuation. Can we agree on that point?
Could you repeat that, Your Honor?
Okay. I'll take it in chunks. Evidence was presented at trial about investment income. Agreed?
Right. Yes.
The trial court did not use that investment income when calculating the amount of income wife received annually. Would you agree?
Correct.
So was the trial court required to do that, number one? And number two, if they were not required to do that, who was required to bring it to the trial court's attention?
Okay, well, if you look at the case law, as far as, like the Deathridge case, for example, the Deathridge case, which they cite to repeatedly, says that the trial court just has to consider the assets that the spouses will be receiving in the resolution in order to determine what their income is. It doesn't say that it has to attribute any particular value to it. It just says that the trial court has to consider it. And the trial court here did consider it. It specifically made a finding on page 13 of the ruling where it said, I believe that wife should keep all of these assets invested so she can access it when she reaches retirement age and so she can access it with the maximum Social Security benefit. Now, the trial court is within its discretion to make that decision based upon the assets presented.
Now. I mean, she was receiving, and I can't remember the exact dollar amount, but she was receiving annual earnings on some of those investments right now that weren't taken into consideration in determining her what she was receiving now.
Well, it's not necessarily attributable income, Your Honor. I mean, frankly, I don't think that there's any testimony in the record to determine exactly where that money went, even if it paid out. Maybe it stays in that account and gets reinvested. That's how a lot of investment accounts work. I personally don't know what particularly happened with that money. If it stays in the account, then it's within the trial court's discretion to say, hey, I think it is within the best interest of the parties, and given the facts before me, given the vast discrepancy in incomes here, I believe that it's the best outcome that this money remains invested until wife reaches a retirement age, and then she can access that money so it can keep her going when she's no longer able to earn an income and she doesn't have to touch the principal.
That's not how I read the judgment. How I read the judgment is she said, look, there's going to be earnings on some of these assets, and since neither side's given me a number, I'm not going to use it. And isn't it your burden to make sure she has that number? You're the one who's asking for spousal maintenance.
Correct, Your Honor. We are the one that's asking for spousal maintenance. I mean, the standard is, it's our burden certainly to show that we believe that the wife is entitled to spousal maintenance. And the trial court made the determination that we did in fact make that showing.
That makes eligibility.
Right, that's eligibility. So if you, and it's within the trial court's...
In the amount, he still has to determine what is the appropriate amount and duration.
Right.
And in determining that amount, you consider all of those factors under subsection B.
Right, which the trial court
Right, but it's still your burden because you're asking for it.
Right.
And you put your client on the stand. She testifies that she went to a financial planner, and the financial planner gave her some information, but she can't remember.
Right.
How's that carrying your burden?
Well, it carries the... that particular part of the evidence did not carry the burden, Your Honor. What carried the burden was the fact that we were able to show this is the amount of money that she makes per year. We presented it through the affidavit of income. We did it through trial testimony. We showed what the reasonable expenses were on a monthly and yearly basis, and the trial court compared those numbers and came to the determination that,
Okay,
yes,
Mr.
she's...
Moore, hold on.
Okay, sorry, go ahead.
All right. I just don't want to lose it.
Go for it.
So, you have to prove up her income. Whose burden is it to challenge the numbers? So it's Mr. Donman's burden to say, you got to consider that investment income?
Yes, Your Honor.
And to challenge your valuation of that?
Yes, Your Honor.
Okay, here's what I'm struggling with. Do you agree with me that if she was receiving $2 a month from an investment, you need to account for that in her income because it is income?
I mean, it depends on the nature of the investment and the nature of the account. I mean, so
I don't disagree. So let's talk simple. I like simple math. Sure. $2 a month. She makes $10 a month from her job. That's $12 of attributable income.
Sure.
Would you agree with me?
I mean, if it's in a retirement or a similar account, something that you can't readily access, then I would say that that's not
but
liquid
who's
income.
supposed to figure that out? Isn't that part of, income? Isn't that your job? Or are you saying it's Mr. Donman's job to challenge that it wasn't included? I just want to know how in a perfect world this would work.
Well, in a perfect world, how it happened was wife's side presented her income. They said, we said, here's, her income, here's the affidavit of income, and here's how much we think that she makes a month. Now, if husband thought that that was inaccurate, if she was making more money than that, if she had other sources of income that were not accounted for, then it's certainly within his purview and his burden to try and prove that and show that. I mean, obviously we have a duty of...
Hold on. There are two burdens here, burdens of production and burden of persuasion.
Right.
And you carry both.
Right.
So he can say, wait a minute, that $77,000 that you put in here for earnings, that's your salary, but you have other assets, monthly assets that you get income for, and which it appears she does. So then it would be your burden to persuade, to both put in the evidence that would indicate how much she gets and persuade the trial court that that was still insufficient.
Well, I think that... Well, a couple of things, Your Honor. First, I believe that we carried the burden of production at the point that we showed the trial court, here is wife's incomes, and we think that based upon her expenses that this is what she needs per month. But beyond that, I think we need to view this in the light of the standard of review here, right? We're only looking to see whether there is evidence in the record to support the trial court's findings. And I certainly believe that there is evidence in the record to support the trial court's decision to tell wife, hey, I'm going to give you 5 years of spousal maintenance at $2,200 a month, so you don't have to pull from your investments and pull from your retirement nest egg that you're going to rely on when you're no longer able to earn an income. And while the trial court certainly did state that she wasn't able to...
When we say investment income,
right,
we're not talking about a decline in the corpus of the investment. We're talking about interest on that investment.
Right.
So drawing down doesn't deplete the value of that asset. This interest is all we're concerned with. So here's my question to you.
Right.
You bear the burden of production and persuasion, and we have in the record testimony from both parties that the Sunrise investment, which they each got some portion of, earns an income. Okay?
Yeah.
We also have Mr. Donman, who's asking for a 2% increase in the investments as to be considered in the income. Now, he mostly focused that argument on whether or not she was entitled to spousal maintenance, but doesn't that argument also go to the amount? I mean, didn't he bring it up?
I mean, that amount, he brought it up on appeal, certainly, Your Honor. Again, I don't remember him bringing it up, or them bringing it up at the trial level. But,
was there a motion for new trial?
I don't recall that issue being touched, post-verdict, Your Honor. Yeah. But to get back to your point, Your Honor, I understand that we're just talking about, the interest income here. But again, like I said, the income on investment accounts need not necessarily be considered interest. A lot of times people don't just take the interest earned on their investment accounts and say, all right, I'm going to go spend this now. No, you keep it in the investment account. You earn more money.
That's a choice.
I mean, that is a choice.
It's
but
a discretionary choice.
Right, and it's a discretion.
And we're talking about a discretionary ability to meet her reasonable needs.
Right.
So why? I think I read Deatherage to say you can contribute you can contribute a reasonable interest on that, but you can't attribute zero.
The way I read Deatherage, Your Honor, is to say that the trial court must simply consider the available assets and the available property, and then include that consideration in their final determination of how to split apart spousal maintenance. And
so if there is property that would earn income under your view, as long as the trial court knows that and thinks about that, it can decide not to use that in determining spousal maintenance. That's within the trial court's discretion.
I believe that is within the trial court's discretion, particularly in this specific instance where wife is very close to retirement and the spousal maintenance award is not for 20, 30 years. It's just for 5 years to get her to retirement age. I think that the particular decision here was within the trial court's discretion, even if you may not think ignoring sources of income would be generally appropriate writ large. And in general, I think that what the cases say is that the trial court need only consider the assets.
The trial court's supposed to consider an asset, investment income, when it's received little to no testimony on what that actually is. I understand they can disregard it, but you're telling me they must consider it. Well, if I have 2 apples, 2 oranges, and 2 pears, and 2 something I don't know, each party takes 1 of each fruit. But how do you divide the last thing? Know what it is. How do you consider something that you don't know what it is? You know it's out there, but you don't know the amount.
Well, I mean, through the exhibits and the financial statements, the trial court had a pretty good idea of what the actual property was. The trial court just didn't want to pull fake numbers from the ether, as husband begs the court to do repeatedly, and then assign a value to those numbers that are completely made up. What the trial court said was, since I don't have solid evidence before me as to what this income can produce, I cannot determine, I don't want to make that determination on my own.
Isn't that clearly saying you haven't carried your burden on that point?
I don't.
And you just told me 2 seconds. Well, it's actually Judge Campbell that it was your burden. So you failed to put the evidence in the record, and the trial court then rewarded your failure by giving it a 0.
I disagree, Your Honor. I mean, we put the evidence of what the assets were in the record. It's just that we didn't assign a certain value to, how much dividends, a house is going to pay off and how much dividends a retirement account is going to pay off. The trial court only, what the cases say is the trial court only has to consider these assets when arriving at its final determination of spousal maintenance. The trial court
tried to.
Right.
She tried to, and guess what? She said, I don't have the evidence. I don't have the evidence to do it. So I'm going to err in the favor of the person as the burden.
I would argue that it actually went against us, Your Honor, because the wife initially asked for 10 years of spousal maintenance at $5,500 a year. That's not what was granted. What was granted was 5 years of spousal maintenance at $2,200, less than a quarter of what was originally asked for. It's not that the trial court, granted wife this great boon and gave her everything she asked for. The trial court granted her only a small portion of what she asked for in spousal maintenance. So it's not particularly fair to say that this was entirely to wife's benefit. The trial court took this into account, said that this small spousal maintenance award for 5 years was all that's needed to get her to retirement age, where she can take full benefit of the assets and the property that was given to her.
So the fact that she received assets that could or would earn income, the trial court you're saying the trial court considered that in reducing the amount from what she asked?
I mean, the trial...
Well, yes or no on that?
I would say yes, Your Honor. And the reason why I say yes is because even though the ruling does not explicitly say that, the review standards say that we will assume that the trial court found as necessary in order to support the award that was granted. And so it's entirely possible that the trial court would have held the fact that the wife's side did not necessarily prove, the small amount of income that would have actually been earned off of the relatively small amount of liquid assets involved here, and said, you know what, I'm going to reduce the amount of spousal maintenance that they're requesting accordingly.
Do you agree with me that if we review this record, your client went to a financial planner, got information about those investments, and did not present any testimony about the value of the income from the assets?
Not in her testimony at trial, Your Honor. I believe that, the record is full of recordations of what these assets are and how much they're worth. But at trial, you're right. She testified that she did not remember what the financial advisor told her.
So if we comb through this record, we're going to find Mr. Donman's request for 2% attributable, or the Treasury rate, attributable income to your client. Is that correct?
Like I said, Your Honor, I do not remember that argument being made at the trial.
So let me ask you this. If we back out of this case and we talk about our perfect world, how should this earned income be accounted for in spousal maintenance? What is the perfect way to handle it?
I think that it depends. I think it's a case-by-case basis, Your Honor. The income earned from assets like this, this is why these decisions are left within the discretion of the trial court. Because the trial court's there to see the parties testify, to really make a determination on the weight of their evidence, how much income they earn, how much those assets are really worth. And it's up to the trial court to make a decision how much income to attribute from those assets to each party at the time to award spousal maintenance. That's why we don't come up on appeal and say we're going to retry the evidence and try and reweigh how much this income is going to be worth, because it's really a case-by-case basis. You can't lay down a blanket statement. Here's how we're going to treat assets in every single instance, because every instance is different. Every marriage is different. The difference in assets and incomes is different every single time.
And I agree. There are no two couples that are exactly similarly situated. But you would agree with me that as a family law practitioner, you need a rule of thumb to go by in advising your clients when you get to trial about income interest when you're trying to either seek or defeat a claim for spousal maintenance.
Are you asking, should there be a general rule of how much interest should be?
Should there be a general rule about interest income, that you need to define it specifically, that you can present expert testimony on the amount of interest, or should we simply choose a rate of interest, or should we disregard it entirely?
I don't think that there should be a general rule at all, Your Honor. And that's because the assets available in each case are going to be very different, whether it's a business, whether it's a house, whether it's an apartment complex, whether it's retirement accounts. They're all different. They all have different rates of return. The economies are different in every instance. And that's why we leave it to the discretion of the trial court to listen to the evidence presented to it, and then believe the trial court's discretion as long as there is evidence in the record to support the trial court's decision, which I believe that there was in this instance, Your Honor.
All right. Thank you, Mr. Moore.
Thank you.
The case is deemed submitted. We'll issue a decision in due course. Thank you, counsel, for your fine arguments. We're going to remain in session and as we prepare for our next argument.